Hi folks, my name is Greg McLawsen. I'm the Affidavit of Support lawyer. I've spent the past 10 years representing folks in federal litigation to enforce the USCIS Form I-864. Today, I wanted to talk about what is sometimes an unpopular issue, which is that a sponsored immigrant under the Affidavit of Support has no legal obligation to seek or maintain work. I wanted to go through the legal reasons for why this is true and why it's probably not as radical of a proposition as people sometimes want to think that it is. So how does this come up? Well, under the Affidavit of Support, a sponsor has a legal obligation to maintain the income of the sponsored immigrant at 125% of the federal poverty guideline. That's a whopping $1,400 per month. When a claimant goes to enforce the Affidavit of Support, so say you're a sponsored immigrant and you are going against your sponsor and saying that sponsor owes you money under the Affidavit of Support, the sponsor always wants to argue that the immigrant, even if they're unemployed, has the ability to work, and the sponsor wants their legal obligation to be reduced based on the money that the immigrant isn't actually earning, but has the theoretical ability to earn. Well, federal courts have recognized for a long time that that is not permitted under the federal statute. The leading case is Leo v. Mund out of the Seventh Circuit. It was written by a Judge Richard Posner, who's considered one of the most prominent circuit court judges in the United States. He's often treated as though he were a Supreme Court justice in terms of the weight of his opinions. So we have it on pretty high authority that the federal statute doesn't require a sponsored immigrant to seek work. What's the legal basis for that? When Judge Posner looks at the federal statute under the Affidavit of Support, that's 8 United States Code 1183A, Judge Posner says, look, the statute and its supporting regulations tell us when a sponsor can get away from his legal obligations. There are 5 terminating conditions that are described in the statute and associated regulations. These are primarily that the sponsored immigrant becomes a citizen or has 40 quarters of work. And the judge says, look, the sponsor is on the hook for their legal obligation until the contract terminates as defined by the statute and regulations. If Congress had wanted to put additional excusing conditions in there, it could have, and it didn't. It's a strict liability scheme in the sense that until those terminating events happen, that sponsored immigrant is entitled to support. Based on what? Based on the person's actual income level. Income, by the way, is defined at the federal regulations 8 CFR 213A.1 to mean taxable income. So if we want to know what that sponsored immigrant is entitled to in terms of damages from the sponsor, it's based on their taxable income. It is not based on what income they might theoretically have the ability to earn. Because, and this is what Judge Posner said, the whole purpose of this statute is to ensure that there's actual financial support for the immigrant. Congress wanted to make sure that the sponsor was the one providing financial support for somebody who needs it, not the American public. Because at the same time Congress created the Affidavit of Support, it made it so that recent immigrants were not entitled to federal welfare programs. So it took away entitlement to welfare programs and it put that financial obligation on the sponsor. So what does this mean in the real world? What people freak out about and think is going to happen is that a sponsored immigrant will see this proposition of law and say, great, that means that I never have to work and I can just rely on support under the affidavit for the rest of my life. That never happens. It doesn't happen. It's a fiction, doesn't happen in the real world. I've done these cases for 10 years. I have never once met a client who was eager for any sort of long-term time frame to be reliant on the affidavit of support. This is not big money. It's just barely above the federal poverty guideline, $1,400 per month. The people who typically end up enforcing the affidavit are very often survivors of domestic abuse, but it's people in tumultuous situations. Usually a marriage has fallen apart and somebody needs financial support for some temporary period of time while they get back on their feet, get their life together. It's not a long-term strategy. Nobody is getting rich off of these claims. Nobody is sitting around for 3 or 5, 10 years, rubbing their hands together and being happy to live off of $1,400 a month. It's not that much money. It would not make sense as a long-term strategy to rely on this. What this legal proposition means, however, this idea that we don't look to the theoretical earning ability of an immigrant, what this means is that we don't have to spend a bunch of time in litigation arguing over a defendant's earning capacity. This is called the duty to mitigate, by the way. Duty to mitigate is the idea that the person has an obligation to work if they have the ability to. So that idea, the duty to mitigate, doesn't apply in these cases. If it did, all that a defendant would have to do in order to create a big, messy piece of litigation would be to simply assert, look, I think that the sponsored immigrant has the ability to work. Then we would get into all of this discovery, that's the formal exchange of financial information. We would get into all of this discovery about the sponsored immigrants, the immigrants' earning ability. If duty to mitigate matters, it means that we're going to do depositions on how many jobs the person has applied for, what their resume looks like, what skill sets they have. It's this big, messy issue. And so the defendants would be in a very strong position to delay and make the case complicated and expensive for plaintiffs to prosecute. But since the duty to mitigate doctrine doesn't apply, that whole line of exploration is just irrelevant. There's no reason to create a case inside of a case to litigate the plaintiff's earning ability because it just doesn't matter. So we don't have to spend months going through discovery and depositions on what the person's educational ability is and what relevance that has to the U.S. job market, because it doesn't matter. The only thing that matters is what the person's actual earning situation presently is. What are they actually earning? That matters, but the theoretical ability to earn doesn't matter. So, to do a quick recap, duty to mitigate doctrine doesn't apply. That means a sponsored immigrant has no legal obligation to seek or maintain work for purposes of a claim under the affidavit. That person's claim is based exclusively on what their actual income is, not based on what they theoretically have the ability to earn. The reason for that is based on why Congress put the affidavit of support into place to begin with. And that, again, is to make sure that there's actual financial support for sponsored immigrants when they need it. And that is a strict obligation placed on the shoulders of sponsors that they can escape only under the 5 terminating conditions set forth in the affidavit and its regulations. What all of this means in the real world is not that people sit around and rely on the affidavit of support to support themselves for many years. That just doesn't happen. What it means is that the litigation is streamlined and doesn't have to be extensively about the person's earning capacity. Because that's irrelevant, we can focus narrowly on the issue of what is the person's present actual income. That determines damages. That means the judgment issues based on what the person's actual present income is, and the case is over. Hope that's helpful. I will put a citation in there to the Leo v. Mund case. And by the way, that case has been followed outside of the Seventh Circuit as well. There's extensive citation to it within the Ninth Circuit. The 11th Circuit Court of Appeals recently cited to it. There are also state-level decisions, including in North Carolina, all of them coming to the same conclusion about duty to mitigate doctrine just not applying. Hope this is helpful, and if you have individual needs about the affidavit of support, feel free to reach out to us on our website. We do free video consultations all across the United States. Take care.